To the second lecture of Law and Technology as it relates to material science and engineering. When we ended last class, which was basically an introduction to intellectual property, trying to get you to think about intellectual property, the types of intellectual property. Remember we talked about the different forms of intellectual property, patents, copyrights, trademarks, and what was the fourth one? What was the trade secrets, exactly. Formula to Coca-Cola. And remember what it is that we talked about in terms of what's required for intellectual property rights to attach. Can we protect ideas? Anybody remember? I see some heads sort of not shaking negatively, but not so sure. Come on. When does intellectual property right attach? Please.
When it's put down in tangible form.
Exactly, in tangible form. So if there were intellectual property rights back in the 17th century and Mozart is sitting there writing his concertos, when does the copyright attach to, would that attach? When would it attach? He's sitting there in his flowing robes. He's got his quill pen. He's got his piece of parchment on the desk in front of him. Beautiful music is going through his head, and as he's writing with his quill pen the notes to his requiem, when do the intellectual property rights attach? When do they become official or recognized? Somebody in the back did this with an imaginary quill pen. Exactly right. They attach as soon as the pen touches the paper. That's the cool thing about intellectual property rights. As soon as they're expressed in a tangible form, whether it's writing with a quill pen, if anybody still uses them, or if you press save on a hard drive, or as soon as they're recorded on a RAM, any sort of memory. So it doesn't even have to be a hard drive or a permanent memory. As soon as they're fixed in any way, those rights attach. Before that, while they're inchoate, when they're just an idea sort of floating around in your head, there's no protection whatsoever for them. And that's something important to keep in mind, especially when you have good ideas, because if you start sharing your good ideas with people before you write them down, before you express them in tangible form, you're not protected. So if you have a computer program, or if you have an invention, or if you have a process, or if you have a design, if you have a clever saying, and you happen to be out with your friends talking about how clever your invention is, or how memorable this phrase is you've come up with, and you haven't expressed it in a tangible form, you don't own the rights to that property. And your friend, hearing them, can go out, write them down, and who is the owner of them at that point? Your friend. Whoever expresses them in a fixed or tangible form first is the owner of the right. It doesn't matter whether you created it or not, in many cases. So that expression in tangible form is all important. Now when we ended up last week, I told you we'd have a little talk, start today's class with what I think is one of the most amazing pieces of intellectual property that exists. Everybody, I'm sure, has been to the Apple store at one point or another and bought something, and they give you this bag, and you put it in the bag, and you take it home, not understanding, I am sure, the number of patents and other intellectual property rights represented by this bag. As you can see, my Apple bag is getting a little bit worn, but it still serves its purpose. So I'll pass it around, and you can take a look at it. And I'd like to go over just a couple of things, because I think this is just a great example of intellectual property. This is the actual schematic that came with the patent for this particular bag. And by the way, Apple is very, very stingy with their technology. If you've ever tried to pick up a free bag at the Apple Store, good luck to you. There is a corporate policy that exists that is designed to protect the proprietary technology that's in this bag. And this bag is representative of, in many ways, Apple's philosophy as a corporate entity. It's just not a utilitarian item. So anyhow, so as I say, it's just not any bag. And this is the description of the item from the patent application that was filed. As Apple describes patent number 20160264304A1, it's a bag container formed of white, solid, bleached white sulfate paper formed of at least 60% post-consumer content. This is a big deal for Apple. They want to be a socially responsible, environmentally responsible company. They discovered that most of the bags that we carry home that are made of recycled materials fall apart. If anybody has walked back from Roach Brothers, especially when it's raining out, and been carrying a bag of groceries and the bag gets wet, what happens? All right? What happens is most bags disintegrate in the rain. Most bags made of recyclable materials disintegrate in the rain. One of the things that makes this bag different is because it's made of 60%, at least 60% recyclable materials, but it's assembled and manufactured in such a way that when you walk home with your computer purchase in the rain, it tends not to fall apart. And that's one of the design features of this bag that warranted it receiving this patent. The bag may be formed entirely of paper with the potential exception of adhesives for fixing together portions of the bag. The handle is formed of knitted paper fibers so as to not feel rough and unfinished in the hand. This may sound obvious, but a lot of thought went into this particular bag, just the way a lot of thought goes into every patentable device. I put this up here because one of these days you'll find yourself trying to file a preliminary patent application. Maybe we'll do it in this class when we cover patents. But you're going to have to come up with an expression of what your patentable invention is in English. And this is the way these descriptions typically are done. I can think of no better example, quite frankly, than this description of the Apple bag. And I can't even begin to tell you how much money Apple paid lawyers to write that description. Knowledge of the English language and the ability to describe your invention is going to be really important. Every invention needs to be described this way. So here is first we had the description of the bag, but here's what we're in the patent application. We're talking about its purpose, its utility. Okay, so the bag with a bag with more than 40 to 50% recycled material may be prone to tearing, like the Roach Brother bags or the Whole Foods bags that you walk home from the store with in the rain. Yes?
Actually, the bottom of the bag says that it's 100% recyclable.
Ah, well, so it said at least 60%, right? Well, Apple has now gone to 100%. So even though it said at least 60%, I believe, right? Okay, so Apple is getting a little bit better. I think when they wrote this, when the law firm that wrote this for them, they wanted to be as conservative as possible, because of course if it was less than 60%, then the patent would not apply. But to encompass as large a universe of products as possible, to protect Apple's investment, They said 60%. Maybe at the time they had the ability to do 80 or 90%. Now apparently they can do 100%. But that's very sharp of you. And it raises the issue of scope of patents and how the description is important. Yes.
80% post-consumer, but 100% recyclable.
Okay.
What is that? What is the difference?
Well, post-consumer is something that has been used before. Paper made from virgin wood is recyclable. So if you go to a mill and you get paper that's never been recycled before, it's still recyclable. That bag may have been a Roach Brothers or it may have been a book, or it may have been a pad of paper, or it may have been a plastic container of some sort at some point downstream from when it was manufactured. In any case, to circumvent this problem, the bag has reinforcement inserts. So not only is the material something that's essential to this patent, but the way it is put together with reinforcement inserts that attach to the folds and gussets to augment the strength and resistance to tearing, the bag container material to make it more structurally suitable for use as a bag. As you can see, that's not a typical bag. It's different than what you pick up at the store over at the Adams Center or at the corner grocery. It really has an awful lot more engineering in it than your typical bag. The bag may be constructed without glues or adhesives. This can help reduce the environmental impact of the bag. I think that one is designed with adhesives. I imagine the adhesives they're using have proprietary characteristics. So not only do we have a design patent, and we have potentially patents on the materials with which it is assembled, but did anybody else notice another example of intellectual property on the bag that may not be covered by patent, but is covered perhaps by another form of intellectual property?
Logo.
Logo, exactly. And what type of intellectual property is a logo?
Trademark.
Exactly, trademark. So Apple proudly displays their trademark on their patented bag. I think that there are, I don't know if anybody did Google this, but I think that there are a total of 43 patents that apply to that particular bag. One bag, 44 patents. Everything from the glues that are used to assemble it, to the design of the tabs that are used to interlock to make it structurally more secure and sound, to the types of materials that are used to assemble it.
What value do you find on doing such a thing? As in, we know that they produce these, high quality devices or for technology, but what value is for Apple to trademark a bag?
A great question. Let me have you answer your own question. I'm going to make you the CEO.
Can you repeat also?
Sure. What value is it to Apple to patent a bag like that? And I think what your question is why or how is it in Apple's interest to invest so much money in this technology? Why don't they just go to a bag manufacturer and take it off the shelf?
Or make the bag themselves, but why would I go to the hassle of, maybe because I have lawyers and stuff and I have to keep them busy?
Too much money? You have too much money, you got to get rid of it with lawyers? I wish that were the case. But in the list of reasons why people patent things, that's if it exists at all. It hasn't in my career anyhow. But think of it. You're the CEO of Apple, all right? You have a brand, okay, that you want to promote. There's a corporate identity that is important to you, that you want to convey. Have you ever seen a bag like this from any other store? I haven't. Okay? In many ways, this is as over-engineered a bag as Apple computers are over-engineered, at least in terms of the quality that we expect from them. As the CEO of Apple, you have a whole marketing division of bright people that you paid, and they come up with ideas for you. And they say, hey boss, I have a great idea that I think will promote our corporate purpose, will be good for marketing. It's consistent with our ethic as a corporation. And we can get a lot of mileage out of this with our customers. It's called goodwill. This is a way that a company creates goodwill. It's a way a company creates in the mind of the consumer an identity of interest. I don't know of any Microsoft bags. I don't know of any Dell bags. I don't know of any, you know what I mean? So, I mean, now, you may be on the board of directors and thinking, this is the craziest idea I've ever heard of. Why should we be spending all this money on a bag? And you may be right. I don't know whether Apple has the ability to study whether this bag, what the ROI on this bag is. All I know is that I'm standing here in front of a group of students at MIT talking about Apple's unique intellectual property, and I'm using their bag. Maybe that's the value. I really don't know.
We were also seeing on the other side of the spectrum, Tesla kind of getting rid of all the, the ownership or letting people do what they have to do.
It's free. It's in the public domain now. That's right.
And focusing, but I understand it.
You know, Tesla, I think, has a different reason. I think Tesla is giving away all of their patented technology so that they can affect the entire market. So no one will be afraid to develop an electric car now. And pretty soon, by 2020, we'll all be driving electric cars. Why? Because Tesla made their patent technology available to everyone. Ford, General Motors aren't afraid BMW aren't afraid to copy that technology and develop it themselves and market their own electric cars. And as we said last week, a rising tide raises all boats. I think in both cases, I think the reason for making this bag the way they make it and the reason for giving away patented technology is the same: profit. They see a way of furthering the interests of the corporation by either giving away that technology or by over-engineering a bag because of the image that it creates in the mind of the consumer. Oh wow, Apple, they like to recycle, they're environmentally friendly, their engineering is better than everyone else's, right down to the bags. You know, I think that has value. I can't speak for the Apple people, but that would seem to be the best idea or the best explanation I can come up with for it. You know, it makes a nice, in many ways it's the same reason they put this thing on the bag right here. And I think maybe they don't want to put this thing on any bag that doesn't meet the standards of quality for the corporate entity. Corporations are like people. They define themselves with a certain way of doing business. They want to create in the minds of the public an image that the public will accept so that they will purchase their product. And intellectual property is the way they do it. Coca-Cola, with their iconic design bottle, with their logos, Mercedes-Benz. Think of every corporation that you can name. It has an identity. It has a way of conveying that identity to the public, and the way they do it is through the exercise of intellectual property rights, whether it be patents, trademarks, copyrights, or trade secrets. Any other questions? Yes, sir. And I'm sorry, could you give me your name first? I promise by next week I'll know everybody.
Kevin.
Kevin, thank you.
So when I look at the bag, it's kind of unique but at the same time, I've seen similar bags. I guess, what is it that makes this bag patentable? Is it the fact that it has over 60% post-consumer content? Does that mean that no one else can actually do that? Or is it the combination of post-consumer content with these reinforcement inserts?
Kevin has a great question. What makes this bag patentable, really? And the answer is, it's different than other bags. And maybe I can answer the question better by explaining how a patent is granted. When a patent, I'm getting ahead of ourselves a little bit, but it's such a great question, I want to use it to introduce concepts that you're going to need to know in order to understand patents. When you have an idea that you want to, for an invention of some sort, whether it happens to be a bag or a better mousetrap, okay? When you express that idea in tangible form and apply for a patent, first, nowadays, what you do is you file a preliminary patent application. And that patent application goes before a patent examiner at the United States Patent and Trademark Office in Washington, D.C. Big building, literally is how it's done. And nowadays, it's all done online. So Apple, I'm certain, took this schematic as part of their electronic filing with the United States Patent and Trademark Office, along with the description and other information about their application to patent this bag, and they sent it in. It lands on an examiner's desk. And at the United States Patent and Trademark Office, they have examiners that specialize in every kind of invention that you can imagine, from carbon fiber aircraft engine fan blades to bags. Literally have rooms like this of people with cubicles, desks, and areas of expertise. Many of them come from engineering schools like MIT, because the knowledge they have within their discrete area of expertise is really essential, because it's their job to decide whether it's patentable or not. So the application will come across the patent examiner's desk. The first thing the patent examiner will do is they'll look at the application, but they'll also look at the database for the United States Patent and Trademark Office, which has every single patent ever granted by the office. And you can literally, I urge you all to do this. In fact, I'll end class a little early today so that you can all, later on at home tonight, justify taking 10 minutes to go online to the United States Patent and Trademark Office website and just look around. This is not rocket science. This is stuff that oftentimes people pay people like me an awful lot of money to do because they're afraid to do it. But you can do this yourself. Go on the United States Patent and Trademark Office website and root around in there a little. If you're going to file a patent application, you will have had to have done a search of what they call prior art. So you've come up with an idea for a better mousetrap, or a better lawnmower, or a better bag. Well, the first thing you have to do is to go on the United States Patent and Trademark website and look up prior art. And you can, it's done by categories: lawnmowers, paper bags, mousetraps, paper cups. And you look at the prior art. And all that means is the prior inventions within that category. And you ask yourself the question, is my design better than that design that Whole Foods came up with? And so if you as the inventor are sitting there and you want to convince the patent examiner that your bag is an advance in the state of the art from anything that had gone before it, you start writing descriptions like this. This is a way of advocating, convincing the patent examiner that your idea advances the art. We'll go into the requirements for patents, including originality and all of the other things, but suffice it to say at this point, all you have to do in order to have something patented, let's take the example of a mousetrap. There are lots of patents on mousetraps. But let's say you've come up with something that's that much better, just a little bit better. Maybe it's more humane, maybe it's faster, maybe it's lighter, maybe it's cheaper, I don't know, whatever. Maybe there's some design, something about the way you've engineered this invention that advances mousetrap technology. And you think it's worthy of a patent because what you want to do is commercially exploit this. You have a better mousetrap, you have a better bag, you have a better lawnmower, you have a better paper cup, you have a better thermos. You think you can make money on this. So what you want to do is protect that tangible expression of your idea. And so you write up an application to the patent office hoping to get 20 years of protection for this so that you can have the exclusive right to commercially exploit this item. And so what you do is you write down in the application why your invention is better than previous iterations of the mousetrap or the bag or the paper cup or the lawnmower or whatever it is that you can think of. And that's how it's done. And then the patent examiner looks at it, and I can assure you that these examiners, for the most part, have advanced engineering and design degrees, and they will decide whether or not your invention advances the art or the science or that invention enough such that it satisfies the originality requirement and therefore is worthy of patent. There's fights all the time about this. You know, somebody comes up with a patent and they get and the patent officer approves the patent. Let's say, I'll go back to my mousetrap idea. Let's say I have ruled the world with mousetraps for a long time, and I have a number of patents on my mousetrap technology. And along Kevin comes with a better mousetrap, and he convinces a patent examiner that his mousetrap is better than mine. And I get wind of it because I go to the store and I say, well, I'm ready to sell, I walk into Jeff Bezos at Amazon and I say, I'm ready to ship my 1,000,000 mousetraps to you for this month. And he says, gee, I don't need them anymore, Steve. I have a better mousetrap. And I go, what? So the first thing I do is I find out who Kevin is, I look at his patent, and then I hire a bunch of lawyers to file a cancellation application with the United States Patent and Trademark Office, arguing that the patent examiner made a mistake, that Kevin's mousetrap does not advance the science sufficiently to warrant a patent, and request that the patent office reverse the decision of the patent officer and grant me my engulf and devour monopoly on patentable technology as far as mousetraps are concerned. That's the way the process works. And there will be a hearing in front of a hearing officer at the United States Patent and Trademark Office. And there will be evidence. And Kevin will bring in scientists to show how his patented technology advances the state of the art. And I'll bring in scientists that say, oh, no, that's all covered by our description. And this gets back to your original question, which is formed of at least 60% post-consumer product. I can talk about how, well, my patent was, general enough to include the obvious changes that Kevin has come up with. So he really hasn't advanced the science at all. I deserve to have complete control over this technology. And the hearing officer will make a decision based upon Kevin's testimony, my testimony, the testimony of experts in mousetrap technology that we bring in to talk about it. Now, you've all heard of the CRISPR decision at the Broad Institute. This is the same thing that's been going on there and continues to go on. And then after the hearing officer makes a decision, if Kevin isn't happy with it, he can appeal the case to the appellate division of the United States Patent and Trademark Office. And if he's still not happy with that decision and it has any money left over, he can appeal it to the First Circuit Court of the Federal Circuit Court of Appeals in Washington, which is the court that handles all patent and trademark litigation. And if he's not happy with their decision, he can go to the United States Supreme Court. That's the way it works. And as between you and me, I'm the million mousetrap a month guy that has captured Walmart and Amazon. Who's going to have the money to win that fight? I'm going to win. I'm going to win. And that's one of the inherent injustices of the world of intellectual property. And one of the reasons why I'm standing up here on my hind legs in front of you is so that you can understand the need to protect your inventions. You're going to have, everybody sitting in this room is going to have at least one brilliant idea in their life that is commercially exploitable that you can make a lot of money on, just statistically speaking. That's who's sitting in front of me right now. And it's important for you to realize, very important for you to realize that you can protect that technology, that inspiration, that product of your insights and knowledge. And not only is it possible, but it's necessary. That's literally why I'm standing up here in front of you. Because it's a gap here at MIT. We teach you to be the best scientists, researchers, engineers, writers in the world, and then we don't tell you how to protect that stuff. It's a little bit like graduating someone from law school and not telling them the address of the courthouse. I mean, if you're going to be going out there, and if we encourage you to be entrepreneurs, we need to show you how to protect this technology. Thank you for the question, Kevin. That's really, now we've covered half another lecture. So, anything else? Any other questions? All right, so that's enough for the bag. I wanted to talk a little bit about copyright. We talked about Mozart. Of course, Mozart is no longer with us, and that was just a hypothetical example because the United States Copyright Office didn't exist at that time. Mozart died long before the Berne Convention that we covered in our last lecture. There really were very few copyright laws back when Mozart was writing his magnificent pieces of music. But it's just one example. A more modern day example, anybody here a Course 6 student? Anybody here do any computer programming? So what does the Book of Mormon and computer programming have in common? They're both considered literary works by the United States Patent and Trademark Office or by the Copyright Office. The law of intellectual property is a very flexible thing. It's been written in a way that allows it to protect mediums that have not even been invented when the laws were written. So back when they wrote the laws governing copyright in this country, there were no websites, there were no well, there was some computer programming going on, but very little computer programming. It was Fortran and COBOL, and nothing like the sophisticated computer programming that the world depends on now. But if you look at the United States Constitution, it doesn't say computer programs, but it's written broadly enough that it encompasses all forms of media. So anyhow, what I want to do is talk about copyright. Copyright. Anybody have any idea what copyright means? What does copyright mean? When you see the word copyright, what do you think?
Controls who has the right to copy and distribute.
Exactly. It literally means the right to copy. And that's a very powerful concept in intellectual property. A patent is essentially the same thing, the right to copy a design or an invention. You don't have the right to copy something that is written or that has been invented by someone else unless you have their permission or unless it's in the public domain. So the right to copy is a very, very powerful right. You come up with a new computer code, something that trades on Wall Street and can make a quarter of a cent a second faster than the next program, you're going to make millions. And your right to control that is essential, is very important. So only you have the right to copy something that you have created. The term has come to mean that body of exclusive rights granted by law to authors for protection of their work. And by authors, I mean computer programmers, I mean photographers, I mean painters, I mean poets, I mean writers. Can anybody think of anything else? Scientists who come up with compilations, publishers. There's anything that has to do with publishing are people that are concerned with that body of exclusive rights granted by copyright. The copyright symbol or copyright sign, everybody's seen the little circle with a, now you know what it means. It means that that item is copyrighted, yes.
Can it also be a presentation?
A presentation. Well, think of the requirement of all intellectual property. What does all intellectual property require before it attaches?
I mean, a tangible form, so a presentation.
Exactly.
Like a file or document can be.
Sure. This video, which is being taken here, is copyrighted or eligible for copyright, I suppose. The slides that I put together here are copyrightable. But the concepts that we talk about here are not. Because we talk about general concepts and ideas. I mean, that's what this place is full of. I mean, this entire place, this entire university is built on ideas. Those ideas are not protectable. It's only when they're expressed in tangible form. So if you want to go out and market something that you have recorded, you can do that. But you better make sure that you're not infringing on somebody else's copyright. And one of the ways that we did that, one of the ways we showed that something was copyrightable in the olden days is to put that little C. You used to have to say copyright. In fact, can you imagine being an artist nowadays with a studio in Cambridge who wants to market their landscapes, all of their beautiful watercolor landscapes all over the world? There's this whole arcane system of laws that have to do with the history of copyright protection that required artists to put that C on the canvas. And you can imagine the artist kind of objected to that because, can you imagine Da Vinci with after he finishes the Mona Lisa, putting that C on there. But that's the way copyright law used to be. In order for the copyright to be protected, you used to have to mark it. That C is kind of like the final iteration of the marks that you used to have to put on materials that you wanted to copyright. So what's eligible for copyright protection? Law applies to original, that's very important, that word is very important, original literary, dramatic, musical, or artistic works. And that includes computer programs and databases, tables and compilations, photographs and drawings, sound recordings, films, broadcasts, cable programs, video recordings, pantomimes, choreographic works, pictorial, graphic, sculptural works, audiovisual works, derivative works, compilations, architectural works, and the more obvious instances of books and journals. Not that anybody reads books anymore, everything is on computer. But if you publish a paper on the computer, it's the same as publishing it in a book because it's fixed in tangible form. It's just not on paper, it's on some RAM drive or some way of recording it electronically. Again, that form of storage or expression was not even conceived of when copyright law was originally written, but it is written broadly enough that any form of expression, electronic or analog, is included. And that's what basically the last point says. And the rights of a work literally authorize you or prohibit you from, or prohibit others from using your work. Why is that important? Why is that important? Why is it important for you to have exclusive control over what you have written? What good is a copyright? Anybody ever read Green Eggs and Ham? Copyrighted. Why? Because the author wanted to sell a lot of copies of Green Eggs and Ham. You can't go into the coop without seeing Green Eggs and Ham. Generations of children have enjoyed Green Eggs and Ham. Can I go out and copy Green Eggs and Ham and sell it on the corner? Hopefully the thought bubbles above your head, which I can't see right now, all are saying absolutely not. That's why these rights are important, because they give you control over your invention. And why do you want control? Usually it's so you can commercially exploit it. And that's the same as if you're a computer programmer, or if you're in a studio in the South End creating a sculpture or a painting. Or if you're a film producer in Hollywood, or if you're writing a book that you hope will turn into a film. How about Harry Potter? What's her name? I can't remember the name of the author. Thank you. She wrote a series of books. How did she become rich? Selling them. And selling the rights to Hollywood producers who will bring her artistic work to millions of more people. J.P. Rawlings has become fabulously wealthy because when she said, nobody cared about J.P. Rawlings when she was sitting there at her writing table writing the series of Harry Potter books. Nobody cared.
It's now the richest person in England.
That's right. They're all over the world. She started she took a manuscript to a small publisher who took a chance on her, you know? And now she's, except in my case, a household name. I need help sometimes, but she has sold millions because the right that she has to copy that work is exclusive to her, or anybody that she licenses it to. And believe me, anybody she licenses it to pays her a lot of money in order to license it. And they license it because they think they can make more money off of it. They hire someone like me saying, well, negotiate a contract with her. I want to produce a Harry Potter series of movies. I'll pay her X number of millions of dollars. And I've sat there calculated in my mind, if I pay her $100 million for the rights to her literary expression, the global rights to Harry Potter, if I market it properly, could be $2 billion. I'll make that deal. And that's why these rights are important. That's why controlling this and preventing others from using it is very important. All right. I talked about this in the last class, and I'll end with this because there's a whole bunch of arcane copyright laws that you can look at the slide presentation for. Suffice it to say that there's a uniform system nowadays of copyright laws that protect authors like you. But remember, we talked about how important these rights are and how important they were to the founders of the United States Constitution. And here's the evidence of it right here, straight from the United States Constitution. That document that was adopted in 1778. Article 1, Section 8. Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. It doesn't get any more important than that's in the United States Constitution. Freedom of speech, freedom of religion Freedom of expression, freedom of association came after. They're contained in the amendments to the United States Constitution. This is in Article 1, Section 8. The founders of this country saw this as such a basic human right that they included it in the United States Constitution. They also understood, being inventors and merchants and highly successful people in their own right, they also understood that this was necessary when you're creating a nation. There needs to be a system of laws which helps the commercial development of everyone. And part of those are the laws involving intellectual property. They really are as fundamental as the right to free speech, the right to associate, the right to the advancement of science. Where would we be without the advancement of science, without the advancement of the arts? Where would we be? How would we define ourselves as a people? That's how important this system of intellectual property rights are. You're one little piece of this. You are going to, each one of you will come up with something in your lifetime, I guarantee it, if you haven't come up with it already. That's going to be a brilliant idea that's commercially exploitable and potentially make you a lot of money. That part of Article 1, Section 8, Clause 8. That's the framers were thinking of you and how important what you do is to our development as a society. More important, you could argue, than speech, freedom of religion, because they all came after. So that's where all intellectual property rights in the United States derive from. And we've talked about how the Berne Convention and the Paris Convention and the United Nations have adopted similar things, mostly following our lead. I talked about the arcane system. I'll just finish with one last thing, and it has to do with how long the copyright lasts, because I can tell that you're probably wondering how long a copyright lasts. Does anybody know how long a copyright lasts? Copyright lasts. There's a system of laws that have to do with how long a copyright lasts. The latest law was adopted in 1978, because this doesn't say, the Constitution doesn't talk about, it just says for a period of time. Congress later on would decide how long these copyrights would last. And Congress has passed a series of laws that talk about how long copyrights last. And the general rule is, and I used to teach all of the rules, but the law changed in 1978. So there's one set of rules that pertain to anything copyrighted before 1978, and there's another set of laws that pertain to everything that was copyrighted from January 1st, 1978 to the present. But since all of you in this class were probably created well after 1978, you yourselves were created after that, I see no reason to talk about what happened before 1978. And it's a lot easier anyhow, because the law is now, the rule is now, that a copyright lasts for the length of the author's life, whoever the author is, and if it's co-authors, it's the surviving author's lifetime, plus 70 years. Plus 70 years. At that point, after the life of the author and 70 years, it goes into the public domain. And the public domain is this wonderful thing. And I'm going to start our next class talking about it. It starts with the discussion of something that everybody, I'm sure, here can sing. Happy birthday. So when we come back when we come on Friday, I'm going to tell you the story of Happy Birthday. Not just because Happy Birthday is an interesting story, but because the story of Happy Birthday basically tells you everything you need to know about copyright law. And we're going to finish copyright law on Friday by telling the story of Happy Birthday. And you'll walk out of here knowing everything that you need to know about Happy Birthday and copyright law. See you Friday. Pastries on